Thank you so much, Judge Rendell, and welcome, Judge Sullivan.
Welcome.
We are here to discuss a difficult case that you have which encapsulates the importance of judicial independence, which is the theme of our seminar. It's the Ted Stevens case. It was a case involving remarkable governmental misconduct, and having read the transcript, I can say that you behaved with impressive principle in ferreting out the misconduct and in appointing an independent investigator to get the facts. You've made my job very easy this morning by preparing a summary of the background of the case, which you've asked me to read briefly, and I'm going to do that, and then I'm going to ask you about what happened in the case. So here's the background. On October 27th, 2008, right before the 2008 election, Senator Ted Stevens, who is up for re-election and was the senior Republican from Alaska, was found guilty by a jury of failing to report gifts on Senate financial forms, including a gift from a man by the name of Bill Allen, who was the CEO of an Alaskan oil company. Senator Stevens lost the election, a Democrat replaced him in the Senate, and the balance of power shifted in the US Senate. There were a bunch of allegations of prosecutorial discovery, abuse, and misconduct during the trial. Senator Stevens made motions for a mistrial and to dismiss the indictment, and you took a number of steps to remedy the misconduct that you were aware of, including ordering the government to produce unredacted grand jury testimony and FBI forms, striking certain evidence, instructing the jury to disregard evidence, and striking parts of the indictment. However, during the post-trial proceedings, it became clear that the Stevens prosecution was permeated by systematic concealment of evidence favorable to the senator. This is in violation of the law, the Constitution, and the prosecutor's ethical requirements. About 6 months after the verdict, Attorney General Holder moved to dismiss the indictment with prejudice and not to seek a retrial. And on August 9th, 2010, tragically, Senator Stevens died in an airplane crash in Alaska. When you learned of the degree of the misconduct, you appointed a special investigator because the case involved a post-trial whistleblower complaint alleging misconduct in the investigation. And one of the allegations was that the prosecutors had deliberately relocated a witness to prevent the witness from testifying at that trial, as well as the concealment of Brady material and Jenks material. Judge, what did you do when you learned about the whistleblower's complaint?
All right. Jeff, first of all, thanks. It's a pleasure to be here. Thanks for getting me out of Washington, D.C. for the weekend. This beautiful building to interact with Judge Rendell, one of my superstars, and Jeff. We talked early on about high-profile cases. I would have loved to have talked about the emoluments case that's pending before the circuit, won't be argued until December the 9th, or the National Security Director Flynn case, but he won't be sentenced until at some point he'll be sentenced. But I can't. But invite me back next year, I'll be happy to do that.
Done. Please come back.
But let me give you a little background. This case, I have another binder, you should see it, it's about this thick, and I was reading all the opinions last evening. I issued 7 major opinions in the Ted Stevens case. That's unusual. I've had the pleasure of talking across the country in various forums, venues about the Ted Stevens case. It's the case that just keeps giving, and it presented a host of issues. I want to back up a little bit, talk about what happened shortly after the trial concluded, and indeed the trial drama. Well, the post-trial drama was just as compelling as the trial drama. But Senator Stevens was convicted in October of 2008. I mean, this man appeared before me. He had outstanding attorneys, Brendan Sullivan, no relation to me, outstanding team of lawyers representing him, and he was one of the first, I think the only defendant who's appeared before me. I've been a judge for 35 years now on 3 courts. He's the only defendant who's appeared before me who enforced his speedy trial rights. He says, I want a trial. I mean, he was up for election. He said, I want to clear my name, Judge. And I said, let's get it on. In the words of Marvin Gaye, it's great. And the government said, I said, can the government do this? I mean, Brendan as you can well imagine, had a team of lawyers representing Senator Stevens. And the government said, we've turned over everything, which, was proven to be false months later. We've turned over everything. We understand we're under a continuing ongoing obligation to produce exculpatory material, and we'll continue to honor our obligations, et cetera, et cetera. So anyway, we got all of that was not true. We started the trial. Senator Stevens was found guilty. 2 months after the trial was over, and my law clerk, who I could not have done any of this without Addie Schmidt, who's now a partner at Miller Chevalier, we're talking about preparing for sentencing, preparing to deal with the multiple motions that would have been filed seeking a new trial because of Brady abuses, et cetera, et cetera. I mean, I did a lot during the course of the trial. I struck evidence. I told jurors to disregard evidence because the government had shirked its obligation to do certain things. I mean, that's how bad it was getting during the course of the trial. Well, in December of 2008, one of the FBI agents who'd been sitting at the counsel table throughout the trial filed a whistleblower complaint. And a lot of these issues I'm going to talk about are so timely now. A whistleblower complaint. He filed it ex parte with the government, and the government sought to keep it secret and sealed. That's right. FBI agent Choi, Chad Choi, from the Alaskan office, talked about moving someone back to Alaska before the trial started so he wouldn't testify because they were concerned about his testimony. This was the star witness for the government. The person ultimately died without providing any testimony. He died without being cross-examined by Brendan and his team. Chad Joy talked about the willful concealment of 302s and Dr. 302 statements by FBI agents, the concealment of evidence. I mean, this was like a 5 or 6 page letter. He was scared to death. He didn't want it to be publicly made available because he was a whistleblower. So for 6 weeks, the government played out this drama with me. And it said, he's a whistleblower, he needs to be protected. And that was not true. This man had been denied whistleblower status by the Department of Justice before the Department of Justice approached me to let me know that it had this whistleblower letter. So a lot of issues were percolating there. I mean, Ted Stevens was a United States Senator being prosecuted by the United States Department of Justice Public Integrity Section in a public courtroom in the District of Columbia. It's a public trial. He has Sixth Amendment rights. The media had an interest, the community had an interest in learning what was going on. The whistleblower had an interest in keeping everything under seal. So that was the first difficult post-drama issue, to kind of balance all of these competing interests and try to figure out what the heck to do without getting reversed. So we had a hearing. There was no authority directly on point. What happens when someone's Sixth Amendment rights conflict with the alleged whistleblower rights? What happens? How should a judge resolve that? This was 10 years ago. I wrote a 29-page opinion. I resolved it in favor of the media, the community, and Senator Stevens. And I held that the complaint should be filed on the docket. But I was not insensitive to the rights of the whistleblower. And although I didn't say, I'm going to post these documents on the public docket in 5 days to give the government a chance to appeal, I didn't add that last part. But what I said was, I'm going to post the documents in 5 days so the government can figure it out if it wants to. And if they want to challenge it, the Court of Appeals, they could certainly challenge it. And the whistleblower, he was allowed to participate in this case. Agent Joy, he could challenge it. No one filed the challenge, so that was a hurdle. You were over that. So what happened to that? I ordered that the unredacted complaint be produced to the defense, and suffice it to say, I wasn't pleased at all by this. I mean, this is the post-trial drama that's starting. And now we're aware that there's additional evidence that should have been produced to Senator Stevens and his team during the course of the trial. That revelation was a week before President Obama was to take his oath of office. And a new Attorney General, Eric Holder, was in place. You know, I had no intention to start this case again with a new Attorney General. There was an acting Attorney General by the name of Casey. So, seemed to me, the better part of wisdom was to directly order Mr. McCasey to sign a declaration telling me everything he knew, everything any other attorney knew at the Department of Justice about this whistleblower and about all this evidence, and to get it in to me within 3 or 4 days. Well, he thought otherwise, and of course they filed a petition that mandamus me with the circuit. But just fine. At least I got a reaction, which made me, and that's what I wanted. And then I rethought it. I said, you know what, I don't need McCasey. I don't need to get tied up in the circuit court and maybe the Supreme Court for the next 4 years or so. So I said, all right, any appropriate high-ranking official can sign the declaration. And the government said, that's fine. I said, okay, then do it. And let's see what the government's been hiding. And I wanted them to produce any and all correspondence from and to anyone in the public integrity section regarding the Joy complaint. The government filed a memorandum document production in response to the court's order. It produced no documents. I ordered the government to file a privilege log of each communication it sought to withhold for approximately 33 documents. It filed no points and authorities. I held a hearing. I couldn't believe this. They provided no points and authorities of law. I said, you know, let's hold a hearing. Maybe there's some misunderstanding here on their part, some misunderstanding on my part what I want done. So I held a hearing and asked government counsel if my order to produce the relevant documents had been complied with. And amazingly, the attorneys looked at each other and they said no. I mean, I was shocked then. Now, I then asked if there was any reason why my order had not been complied with. They kind of looked around again, like Colbert or something, you know. And they said, no. So they understood the order and there was no reason for non-compliance, for compliance. So I did something I've never done before, and I didn't enjoy it. I'd never, up to that point, have never held anyone in contempt of court. I held every attorney from the Department of Justice, including the head of the Public Integrity Section, the deputy head of the Appellate Section, and whoever else was in the well of the court, in contempt of court, civil contempt of court. He gave them 2 days to purge their contempt. I've never done it. I'd never done it up to that point. I've never done it since, and hope I never will have to do it again. The government appealed. All the attorneys appealed. They had excellent lawyers. And essentially their argument was to the circuit court, you know, Judge Sullivan was so upset at us that now we really have the stigma of him having held us in criminal contempt, not civil contempt, judges. And for that reason, you know, we were asking that he be reversed, which prompted Harry Edwards, I think it was Harry or Judy Rogers, to say on the record, let me get this right. So what you want us to do is to send the case back to this very upset judge so he can properly hold your clients in criminal contempt? Is that what you want us to do? And they kind of very sheepishly said, yeah, kind of what we want. Well, I was affirmed on that, and I never took any pleasure out of that. I was affirmed. So what happened after that? You know, Eric Holder took became the Attorney General, and there was a new, after I held those attorneys in contempt, Eric had to appoint a new team of attorneys because all the Stevens teams had been held in contempt. I guess they were precluded from further participation, and the new team of attorneys found yet and still even more evidence that had been withheld. Eric moved to dismiss the case with prejudice. Eric was a new Attorney General. He didn't want to start off his career with dealing with this case. It didn't take him long. I mean, he and I have never spoken about this, but I'm sure it didn't take him long to say, I'm not dealing with this. And they were satisfied that there was a ton of evidence, exculpatory evidence, that still had not been produced to the Stevens team.
But what reasons did the government give, and what was your response?
Well, the reasons they gave for dismissal with prejudice was because the new team was convinced that exculpatory evidence had not been turned over, and that Senator Stevens had been deprived of a fair trial, and they wanted to dismiss it with prejudice, which made all the sense in the world. It just seemed like that wasn't enough, not because of me. It just seemed like that was unfair to Senator Stevens, though, and also to the community. I mean, the community has a stake in the fair outcome of trials. So we did a lot of research on this. I said, this can't be the outcome. I said, it makes no sense for me to take that under advisement for 2 years or so and try to figure out what to do. Of course I'm going to grant the motion to dismiss with prejudice. And everyone appeared. I set it scheduled for a hearing, and everyone appeared. Senator Stevens spoke. I think his wife spoke. Brendan spoke. And everyone, I assume, thought they were going to get home in time for the soap operas. But that was not to be. And was not to be for compelling reasons, I maintain. There's a rule, Rule 42, that talks about criminal contempt and what a judge can do. And it says the court must request that the contempt be prosecuted by an attorney for the government. And I said, well, that doesn't give me any comfort, because it was the Department of Justice that had screwed Senator Stevens out of a fair trial. So I'm going to appoint the Department of Justice to investigate the prosecutors? No. But there was no script. There were no other cases out there. There was a caveat, there was a comma, unless the interest of justice requires the appointment of another attorney. So we started thinking about that. Who could we appoint? It had to be some outstanding individual who didn't have an axe to grind with the government, that's for sure. Who doesn't have an axe to grind with the government? You're an outstanding defense attorney. We thought long and hard. I interacted with Hank Schilke, Henry Schilke, who was a partner with Schilke Janice Weschler. He was also the counsel for the Judicial Disabilities and Tenure Commission and Superior Court. And because I was Superior Court judge, he interacted with the attorneys. I had the highest regard for him. Plus, he had been the #3 person in the U.S. Attorney's Office. He had done some work on the Hill, as well as the Senate, and had a sterling reputation. And he was no nonsense, too. I mean, he was kind of, I don't know if people in this room remember the series The Rifleman. He was kind of like the Rifleman. You know, when he came into Dodge City, you know, the crooks would leave town. You know, so. And I said, you know what, I kid him today. I said, Hank, this investigation of his took 3 years, by the way. I said, if you knew then what you know now, would you have taken my phone call when I called you to ask you? He didn't hesitate. I told him, we can't pay any money. I said, the administrative office will allow you to be paid $200 an hour. He says, no, I'll do it. It's not the money. And it wasn't the money. And he worked hard for 3 years to try to figure out just what happened in the case.
Can I just read a little bit from your comments at the
Sure.
hearing? Because the controlled indignation that you expressed is so striking. You called the government's conduct shocking. You said the court has been repeatedly told that the Office of Professional Responsibility is conducting an investigation. That was 6 months ago, and as yet to date, the silence has been deafening. You said you look forward to receiving the results of the investigation, but until then, you're going to commence criminal contempt proceedings, and because of the rule, you will appoint an independent investigator and focus on the court's decision to set aside the verdict. Was that a hard decision?
Absolutely.
To appoint the independent investigator?
It was one of the 3 most difficult decisions because there was no script for that.
Yeah.
There was no precedent for that. And I just assumed that the new Attorney General, Eric Holder, I thought he would appeal that as well. And you can imagine my sigh of relief when I saw Eric being interviewed on one of the news programs that evening. He says, no, we intend to fully cooperate with Judge Sullivan. And so that was another bullet we dodged. I mean, there was no appeal in the whistleblower case. I'm not sure how that would have been resolved in the Court of Appeals. I think I would have been affirmed, but who knows? This one, just think about it, appointing a private attorney to investigate Department of Justice lawyers. because they didn't do their job, because they deprived a citizen of a fair trial? I mean, it's bold, but we wrote on it, we talked about it, there was some authority for it. Was it atypical? Yes, it was atypical, but I felt as though the public, the media, and especially Senator Stevens needed to know what the heck happened so that we could attempt to remedy those problems in the future. So that was difficult. The other two difficult opinions were holding those prosecutors in contempt. I didn't relish that at all. I had to do it. I mean, if you're that bold enough to tell a judge, we didn't comply with your order, and no, there's no reason we can think of for not complying with it, then, you've earned that contempt citation. I mean, it was pretty shocking what happened. And the third significant order was Rule 42, unsealing the whistleblower complaint, and the contempt in that order. Those three. And there were 6 more opinions I issued, all First Amendment issues.
Those First Amendment opinions are so powerful, and you talk about the public's right to know, you're weighing the privacy considerations, you invoke the Sixth Amendment right to a public trial, and ultimately you say the public has a right to the redacted transcript.
Right, exactly, right. And I felt very strongly about that then, and more so now.
And what was the result of the independent investigator's investigation?
Mr. Schilke investigated this, and along with another outstanding attorney, Bill Shields, for 3 years. He concluded, this is $200 an hour. I mean, he's a partner at a major firm, and I'm sure they're looking at him like, when are you going to finish this $200 an hour gig? Hey, get back to work. But there was no pressure. They were very supportive of him. He concluded that the investigation and prosecution of Senator Stevens were permeated, and these are his words, permeated by the systematic concealment of significant exculpatory evidence which would have independently corroborated Senator Stevens' defense in his testimony and seriously damaged the testimony and credibility of the government's key witnesses. He further found that at least some of the concealment was willful and intentional and related to many of the issues raised by the defendant during the course of the trial. He didn't recommend prosecution for criminal contempt, and this is probably the only point that Hank and I disagreed with, because he found that the court did not issue an order specifically instructing prosecutors to obey the law. Now, but I mean, was I going to argue with this man who had been working for 3 years? We would meet once a month and he'd give me progress notes. He knew I disagreed with it. But by the same token, I'm an objective judge. I appointed him to make a recommendation. What am I going to do, fire him and say, I don't like your recommendation? I mean, no, I'm not going to do that. But I didn't agree with it because, and he did say in his order, he said, I submit that no one should feel as though the court was compelled to craft such an order with a view toward a criminal contempt prosecution, anticipating its willful violation. But he thought that there should have been a more clear and unequivocal order. And that's fine. We learned about the problems. We learned how the problems were allowed to continue at the Department of Justice. I mean, supervisors were blinking reality. They were approving this at the Department of Justice. And then, that produced additional drama because there were all sorts of efforts for the prosecutors to persuade the court to allow the report to be filed under seal. They didn't want this public. They didn't want any of this stuff public. They didn't want the public to know how public trial could have been contaminated to the extent it was. So, I put in place a briefing schedule, audit briefing. We had a hearing, and trying to balance those same interests again, the defendant's right to public trial. These were trial materials. So the defendant had a right to those trial materials, that report, even though it was post-trial. The public certainly had a right. I argued, wrote an opinion. There was one appeal filed by one of the attorneys, and then he subsequently withdrew. So there were no major appeals in this case, which, I haven't been that lucky since.
Well, especially since there was so little precedent. As you said, there hadn't been a lot of these independent investigations. Here's the opinion. Oh, and how, you invoke the First Amendment and the Sixth Amendment. There are a couple of press cases that basically are you writing on a clean slate, and take us through how you balance the constitutional considerations.
All right, well, it was easy in my mind. You know, this, again, this is the public official being prosecuted by the Public Integrity Service Office of the Department of Justice in the United States District Court. This was not a civil proceeding. So he had a right to a public trial, was my view, and that was his view as well, articulated by Brendan, that these documents should be made public, because the public, the media, the community, they also have First Amendment rights to know what the heck is going on in our public courtrooms. And what was it that the prosecutors were trying to keep quiet? Their active, willful concealment of evidence to deprive a United States senator of a fair day in court. And that paled in comparison, that right paled in comparison to everyone else's more compelling interest.
Is that the way they articulated the interest, or did they come up with something else?
That's pretty much what they came up with something else. I mean, it wasn't that stark, but in my opinion, I pretty much said the same, what I just said a little while ago, because that's what it was.
Yeah.
I mean, it was a fraud perpetrated not only on Senator Stevens, but the community. Department of Justice, Public Integrity Branch. We're talking about the director and the deputy director approving all of this. William Welsh and his deputy. It was outrageous. I've not been asked to set aside those contempt citations. You know, I mean, will I at some point in the future? I don't know if I will. I mean, if the worst thing you have to report is that you were held in civil contempt and that you didn't go to jail, then you know what, you've still earned that. But no one's asked me to, I'm actually kind of surprised no one's asked me to set it aside. But they did purge themselves of contempt at some point. And again, who wants to have to report that? But by the same token, they earned it.
So we've talked about a number of extremely tough issues in this case, the decision to hold in contempt, the decision to appoint the investigator, the decision to make the reports public. What was the toughest decision you made?
I think the original decision under Rule 42, because there was absolutely no precedent for the court to appoint. I mean, there was some language in Rule 42. If the court can't appoint the Department of Justice to prosecute contempt, the court could consider another attorney, but I don't think it had ever happened before, and I wasn't that optimistic that our circuit would approve that. But it was just, I guess, I was just fortunate that we had a new Attorney General, and I guess he didn't want to waste any energy on this case, and they didn't authorize an appeal. So we dodged that bullet also. So, yeah, we're very fortunate.
Well, this case has had some salutary effects,
Yes.
including raising awareness of the need to disclose Brady material. And I was pleased to learn that there's a bipartisan bill pending before the Senate that would require both parties to be notified of their obligation to turn over Brady material. Tell us about that bill, and tell us about how you now greet that instruction in your courtroom.
Yeah, I have a standing Brady order that's posted in every case. And it's actually I can go so far as to say that's no, I won't go that far. I posted. I was going to get into a pending case. I should not do that. But it's posted in every case. I don't have any problems with the U.S. Attorney's Office in D.C. and Main Justice. I mean, people comply with the order. Sometimes people just need to be reminded that they have obligations, and a court order is a pretty powerful reminder that you have an obligation. And people know that some prosecutors were held in contempt, unfortunately, for not complying with those obligations. So I have a standing order. We now have a standing rule in our federal court, United States District Court for D.C. I was absolutely delighted to find out about this bill. I heard that was introduced in May of this year, and it actually was introduced by Senator Sullivan. So I hope that's a good sign.
Yeah, that's great.
No relation.
Yeah.
And it's bipartisan.
Yeah.
I mean, let's vote on it and get it to the House. I mean, if people are serious about, reform in the criminal justice arena, This would be a great start. And it just it doesn't tell the judges what to do, which is good, but it says for every district in this country, a court must promulgate a local Brady rule. That's even better. So again, it doesn't intrude on the judge's independence. It doesn't say you have to say this, that, and the other. It just says, do it. I mean, Brady is Supreme Court precedent. It's out there. But everyone kind of has a different view about what their obligations are under Brady, except in my court. I don't have any problems anymore, and probably will never have any more problems. But I do have, I wish life were that good in other cases, you know. But I do post that in every, and some of my colleagues are doing it across the country. They're doing it, and I get calls from judges, can you send me a copy of your current order? We're constantly making changes. There is not a materiality component in the Brady bill. We're constantly modifying it. At some point, will there be a challenge in the Court of Appeals? I mean, there could be. But, you know, I think my job is to continue to consider what I'm currently using, the tool I'm currently using, and to, if at all possible, improve on that tool in the future.
We're going to take questions in 1 sec. I'm just going to say that it is encouraging that criminal justice reform, in particular around fair procedures, does seem to be the one issue in this country that Congress has some bipartisan agreement about. We just had a great event with the Constitution Center in Washington with Senator Mike Lee and Representative Mary Jo Scanlon about the Fair Chance Act, which actually passed.
Can I say one? Can I make one?
Yeah,
other point?
I want to ask you about
not
it.
about Stevens,
Yeah.
but something else that should be seriously considered by politicians. I can't go out and confront people, but you folks can. But if you know, no, seriously though, if people are seriously considering proposals to address the overpopulation in prisons, they should seriously consider the utilization of deferred prosecution agreements for individuals. There's an opinion I issued, Sanatech versus U.S., S-A-E-N-A, Tech versus U.S., and I can send it to Judge Rendell. But I approved a deferred prosecution agreement for a corporation, thereby making it impossible for anyone to appeal. But it gave me a springboard to talk about the dearth of deferred prosecution agreements for individuals. There have only been 5 or 6 in the history of my court.
Tell us what a deferred prosecution agreement is.
Deferred prosecution agreement means, and it's a component of the Speedy Trial Act. Let me back up a second. If you could believe this, 30 years ago, the United States Congress was actually concerned about the large number of people going to jail. Congress. And they said, we have to do something about it. We have to afford people. No, seriously, read my opinion. We have to do something about this. So they looked at the Project Crossroads project in D.C. They looked at a New York project that afforded individuals an opportunity to demonstrate rehabilitation while being in the community. And they carved out an exception to the Speedy Trial Act that set forth, I believe, at 18 U.S. Code 3161B. It's in the federal code. It's there. It's a tool. But we judges can't get involved and negotiate DPAs. We can't do that. But it's there. And it doesn't cost anything. People can enter into a deferred prosecution agreement if everyone says, all right, essentially, I did it. The government's going to defer prosecution on these conditions for a period of time. And as long as I abide by the conditions, which is like pre-conviction probation or so, then the charges will be dismissed. That's a powerful tool that was intended for individuals, not corporations. Maybe just individuals with nonviolent offenses, but I wouldn't go that far. I wouldn't rule out certain violent offenses, but certainly individuals who have been convicted of nonviolent offenses. It's a powerful tool that needs to be talked up because it doesn't cost anything. It doesn't cost anything to keep someone in the community who's doing well, who's abiding by the conditions the judge has imposed, and it benefits society because don't we want people to be rehabilitated? It's not being talked out there. I can't talk it up. I can write about it, and I'll send it to you. You read it. You can talk it up. I don't think there's anything wrong with me saying that.
That's a great suggestion, and we will talk it. Well, while you guys are thinking, I'm not going to miss my chance to talk to the judge. This is an amazing man who just so inspiringly stood up for a fair and impartial judiciary. And I guess I want to ask you, because that's the topic of our symposium, what aspect of the trial is it that you think most guarantees a fair and impartial judiciary?
From the judge's perspective?
From the judge's perspective, it's a big question. But
Yeah, it's ongoing. I mean, from jury selection, which is extremely important, to, I had a trial not too long ago, excellent criminal defense attorney. He got up in opening statement and he said, you know, the government's case is just falling on his face, blah, 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 blah. I can't wait until we put on our evidence and prove that my client is innocent. Well, why do you want to assume that burden? No one has the burden of proving innocence. I mean, the stakes were high. This man was facing mandatory minimums. One of the new circuit court judges had come down because she hadn't been in a courtroom in a while. She said, damn it, what you doing? I said, come on down, it'll be interesting, right? So immediately, I mean, I can't be, as Brendan used to say, a potted plant. I've got to do something. I've got to do something, otherwise it'll probably go up on plain air. The judge should have said, ladies and gentlemen, you know, arguments are not evidence. The burden rests with the government to prove guilt. It never shifts to a defendant to prove innocence. So I did what I should have done without embarrassing the defense attorney. I mean, at the break, I asked him, what the heck got into you? And he said, oh, Judge, too much coffee, the adrenaline was flowing. I mean, you're slow walking your client to jail, for God's sake. So there's no one point. It's ongoing. It starts with jury selection, and you can't just sit there and go to sleep and say, well, I've done my job, and I've selected a jury, and now it's up to the jury. I have to be, you know, I have to pay attention and step in. No one asked me to step in. The government didn't ask me to step in. I mean, you know, and I don't think if I'd been a government attorney, I wouldn't have objected either. Let him prove his innocence. And he wasn't able to do so, but he's facing mandatory. So, and that was not an issue in the Court of Appeals after the conviction. It's ongoing from start to finish.
you know what is so striking to me? There's an interview with you about the Stevens trial, and the journalist who's interviewing you keeps saying, did you think he was innocent? And you keep saying, that's not my job to decide whether someone's innocent. The question is, has the government proved the case beyond reasonable doubt? And he keeps pushing, and you make clear you will not even allow yourself to form an opinion about whether someone's innocent because you don't think that's the judicial role. And when I read that, I thought that is the definition of the way the judge is supposed to approach a case.
He slipped that question in on me. I didn't know he was going to ask that question, and I didn't have a chance to think about it a lot. But it's not my job. I mean, it's not that, and that was my answer. Now, I never did formulate an opinion, and I think it's problematic when judges start formulating opinions about whether someone's guilty or innocent. I mean, is that going to impact decisions that the judge makes about instructions or fairness? I mean, it's not my job. It's up to the jurors, and I never did think about Stevens or so. I did tell you one story that absolutely, after all the evidence, I did disagree with the verdict, and I'll tell you what happened, and I tell my students, pay attention. Pay attention. Students memorize everything. They memorize opening statements, closing arguments. They don't pay attention to what the adversary is saying. And you know what? No, seriously. In this case, this was a difficult case, constructive possession of drugs and guns under a mattress, all right, in an apartment. Prosecutor did a very good thing. Constructive possession is hard to prove. He had his keys, put his keys down. I still possess them. Walked away. I still possess them. Got to the door. I still possess those keys. And he did a great job. Defense attorney was paying attention. He gets up and says, you know what, ladies and gentlemen, I'm going to surprise you. When I tell you, you're probably going to be surprised when I tell you I agree with the government's attorney that if we're talking about constructive possession of keys in plain view on a table in a federal courtroom, the government's proven its case, but that's not what we have here. Oh, man, that was, you talking about right on. I just wanted to take my robe off and go down there and argue myself. That's where the fun is. And you know what? I can look back on that case. I think I may have had a different opinion about the guilt or not guilt of not guilty of the defendant. But that defense attorney did what he was paid. He walked his client. They walked out of the courtroom together.